the issues before the Supreme Court and the circuits on administrative law, and so I thought I would open things up with the broadest possible question for each of the speakers, beginning with Professor Mascott. Of everything that's happening in administrative law and the separation of powers in the courts, what's the most interesting issue or case to watch?
So I think one interesting case to watch is going to be argued by in front of the court right out of the gate the first week of argument on Tuesday, October 2nd, Gundy versus United States. And so this is a case that could be significant because it involves the constitutional challenge to a statutory provision involving a doctrine known as the non-delegation doctrine, which I'll explain in just a minute. But the non-delegation doctrine, basically, if the Supreme Court decides to reinvigorate the doctrine in this case, which it has not really relied on for 80 years, it could have an impact on how Congress is able to write statutes in the future that regulate and govern the behavior of administrative agencies in the executive branch. That said, I think this case presents the issue in a way where the case could be resolved on fairly narrow grounds. And so, you know, we'll have to wait and see how far the court decides to go in this case. But basically, the facts of the case are that Petitioner Gundy is challenging a portion of the Federal Sex Offender Registration and Notification Act. The act requires that individuals convicted of sex offenses have to register with the government, notify the government when they move to a different place, have a new job. The act was enacted in 2006, and one thing that the act on its express terms seemed to leave open is whether offenders who were convicted before the enactment of this legislation in 2006 have to comply with its registration requirements. So the act doesn't directly answer the question. Instead, it says the Attorney General shall have the authority to specify the applicability of the requirements of the subchapter to offenders convicted before the act's enactment. And so arguably the text of the statute leaves it up to the Attorney General to decide what some might think is a pretty big question about whether this new set of requirements for people impacts those who were offended prior to 2006. That said, when the Department of Justice first interpreted the act after it was passed, the Department of Justice said one possible way to interpret the act is that by its terms, it just automatically impacted everybody. The act just says generally that offenders have to register. The definition of offender is fairly broad-based. And so the Department of Justice said that it'd be possible to interpret the statute on its terms to apply to everybody. To be on the safe side, the Department of Justice, the Attorney General, went ahead and explicitly applied the statute retroactively. What's interesting, however, is in the meantime, in 2012, the Supreme Court entertained a challenge to this specific provision in a case called Reynolds versus United States. And in a 7-2 opinion in that case written by Justice Breyer, the court seemed to determine that the act actually by its own terms did not apply to previously convicted offenders, and that the Attorney General actually had to take action to make that aspect of the act effective. Justice Scalia and Justice Ginsburg at the time, in an opinion written by Justice Scalia, dissented from that decision. And one of the things that Justice Scalia said in his dissent was that under the opinion adhered to in the Justice Breyer majority opinion, in Justice Scalia's view, that came awfully close to interpreting the statute in a way that would violate the non-delegation doctrine. And it's somewhat curious for Justice Scalia actually to make that claim and to believe that there might be a non-delegation doctrine, because he over the years had written upholding the constitutionality of quite broad standards. For example, in the Whitman versus American Trucking Association case, there was a standard governing the EPA had to regulate in a way that was requisite to protect the public health, which some might think sounded broad. Justice Scalia did not find that to be a non-delegation doctrine violation. Nonetheless, in his view, this particular provision of SORNA, if in fact it leaves the Attorney General up to retroactively applying the requirements, in his view might cause a non-delegation problem. As I mentioned at the very start, just the fact that the non-delegation doctrine is really before the court squarely at all is just interesting to think about, because the courts only applied the doctrine to find statutory provisions unlawful twice in its history. It happened twice 80 years ago at the height of the New Deal. In the meantime, since then, the court has cemented this idea that as long as a statute provides an intelligible principle to the executive branch or to administrative agencies, the statute provides enough of a standard for the administrative agencies to act. The source of the non-delegation doctrine is thought to be right at the start of the Constitution, Article 1, Section 1, what's known as the vesting clause, where it vests Congress with legislative power. And so the idea would be that Congress then has to be in charge of establishing policy. If there's going to be a new binding standard that, that governs people, it has to be put into place by Congress. And so therefore, Congress has to legislate with enough specificity that it's not actually the administrative agencies or the executive branch that's making up completely new policies or completely new law. But as I say, the court has said as long as there's an intelligible principle, or as long as, I believe other languages, as long as the executive branch can basically discern what it is to do under the statute, then it's fine. I think because of that, when Mr. Gundy first filed his petition to the court, at the beginning, actually, the government did not even file a response to the petition. It just sort of let it go, because I think the assumption, if you look at past history, was that the court would not take up this case again. That said, there was a call for a response in the case, which can be made by just one justice who has interest in the case. Interestingly, when he was on the 10th Circuit, Justice Gorsuch himself had expressed a view that perhaps this portion of SORNA constituted a non-delegation violation. So the government finally did have to respond, and in its response was still pretty to the point, and a lot of the response is actually just string cite of case after case, either where the court had denied a petition to challenge on the non-delegation ground, or had found there not to be a non-delegation problem in this particular legislation in the lower courts. So that would lead us to think maybe this isn't that big of a deal. Nonetheless, the court granted cert in the case. And so it'll be interesting to see how the justices line up, because we know Justice Gorsuch thinks there might be a non-delegation problem with the statute. Justice Thomas over the years has expressed interest in revisiting the intelligible principle standard and perhaps giving clearer guidance to Congress as to how it's supposed to legislate. You might think that justices who are interested in issues of due process or notice for criminal defendants might be interested in finding there to be some issues here with the legislation. In fact, there are a number of amicus briefs that have been filed on behalf of the petitioner, which represent an interesting coalition. There's the ACLU filing on behalf of the petitioner, and then the most well-known conservative interest groups, conservative constitutional interest groups as well. So there's an interesting coalition. Perhaps because of the coalition, if there's not an agreement among the more traditionally conservative justices to really reinvigorate the non-delegation doctrine, I think it's possible we might see a narrow ruling finding that this particular provision is impermissible under the ground that it actually provides no standard. Because if you look just at the provision itself, it actually, right in that particular subsection, does not tell the Attorney General at all what he should consider in determining whether to retroactively apply the requirements. The counter-argument that the government raises in its briefs is to look at all the surrounding provisions and the general purpose of the act, that it's to be clear, make sure there be transparency, have to have a record of where offenders are living. So I think the government will say, actually, all these surrounding provisions give plenty of a standard. If the justices want to resist that and find that there's a non-delegation violation, they could on the other side say, well, actually, here in this particular provision, there's no standard at all. And maybe get out from under this idea of having to revisit the intelligible principle standard. So I think there's a number of ways the case could come down, and it'll be interesting to see in the questioning on October 2nd whether justices are really asking questions that suggest they've thought through perhaps a different non-delegation standard than the intelligible principle doctrine.
Well, thank you. Aditya, what are you watching?
Well, thanks, Adam. Thanks for getting the gang back together this year and hosting us. I was reflecting before we got together and came into the room on our discussion last year, and I thought last year that a theme for the cases the court was about to consider was the unusual place of non-Article III adjudication in the constitutional scheme. And it turns out that the symposium you're going to host tomorrow is about that very topic. We saw two major cases. The first, the oil states case, which is about the scope of an administrative agency within the Patent and Trademark Office to adjudicate certain types of patent disputes. And the second, the case that Adam mentioned in Jen's article was so influential in, the Lucia case, which was about the constitutional mechanism by which administrative law judges, ALJs, should be appointed. And so we saw that. That was the theme for last year. That's the past. In terms of the future, regrettably, I think I really don't have a theme for this year. I agree with Jen that I think the most important current administrative law case pending before the court is the Gundy case. And so I scoured the court's docket and I found two sleepers. So these are the two sleepers that I have in mind. And then one important issue that's currently pending before the lower courts that I'll talk about and flag for you all. So the two sleeper cases, the first is the BNSF versus Loos case, LOOS, and it's being argued in November. It's going to address the exciting question whether a railroad's payment to an employee for time lost from work is subject to employment taxes under the Railroad Retirement Tax Act. So here are the 6 things you need to know about the Railroad Retirement Tax Act. That was a joke. I'm not about to get into the Railroad Retirement Tax Act. But it so happens there's a whole dispute in the briefs about the application of what we all call the Chevron doctrine and issues of judicial deference to executive interpretation in the context of the case. And this is the bread and butter of administrative law, which is what sources should the court be looking at before it in fact turns to some sort of presumption that the executive agency gets its way in terms of interpreting the statute, and there's a dispute there about the meaning of the statute, about the statutory history, things of that nature. And so the case is going to be argued in November, and as we've seen on several occasions in the past couple of years, cases of this nature have prompted interesting dissents and concurrences about the broader applicability of the Chevron doctrine, and conceivably we might see one again. So I guess what this illustrates, and I think Aaron is going to pick up some of these threads about Chevron issues lurking in other cases before the court, is that any one of these cases that deals with the Chevron doctrine in some depth could end up being an important blockbuster case before the term. To be determined, we'll all look for the oral argument in the BNSF Loos case sometime in November. So that's one of the cases before the court right now. A second case, and this is one that I think would not jump out at you as a big administrative law case, but conceivably could be, it really depends, is a case that will be argued next week. It's called Nick versus Township of Scott. And it's a case that is going to address the question whether the court's rule in this precedent from the 1980s called Williamson County, whether that rule ought to be abandoned. And for those of you who may not be familiar with that rule, the basic issue there is whether when an individual claims that they've had their property taken by a state government, whether that individual has the ability to sue immediately in federal court using the statutory mechanism that we call Section 1983 to vindicate civil rights, immediately in federal court, or whether they have to exhaust state avenues, which means litigate their claim through state court first, up to the Supreme Court, at which point it so happens that your claim in federal court would be precluded, and so you really would not have an opportunity to litigate in federal court. But the way in which Williamson County conceptualizes this issue is that your claim is not ripe in federal court until you have litigated in state court and the highest state authority has denied your claim for money because of the structure of the takings clause of the Constitution, which says that the property shall not be taken except for just compensation. And so we don't have a constitutional violation, according to the court in Williamson County, until the just compensation has been denied. And we don't know when that it's been denied until the state courts have addressed the question. Well, so why is this conceivably an administrative law case? I mean, I think the best way that I can illustrate this is with perhaps the biggest separation of powers case of them all, Youngstown Sheet and Tube, this famous separation of powers case decided in 1952, which deals with whether President Truman had the statutory and constitutional authority to seize steel mills during the height of the Korean War. And if you look carefully at Youngstown Sheet and Tube, there is a part 1 to the opinion that actually deals with the question of Williamson County. Because if you think about the issue that's at stake in Youngstown Sheet and Tube, it is whether you can sue to enjoin the officer in order to stop the seizure from occurring. And one of the government's arguments in the case, was that you can't sue to enjoin us. We've provided this monetary remedy for you in the Court of Claims. And so the way in which you ought to vindicate your rights under the Takings Clause is to abandon your injunctive suit against the officer, against the secretary in that case, and go to the Court of Claims and sue for money damages. And the reason why these two issues are connected is because you might think of that question as really being the same as the ripeness style question at stake in Williamson County. And so the issue is whether your lawsuit in federal court is ripe at the moment that you file it, or whether you have to somehow exhaust your remedies in the Court of Claims before you can file that lawsuit in federal court. So it so happens that the Solicitor General in the Nick versus Township of Scott case has filed a brief arguing that Williamson County was wrongly decided and state cases brought against state governments are immediately ripe upon being filed in federal court. And it so happens, I think, if you read the case carefully, the Solicitor General is very concerned with disturbing the framework for Court of Claims litigation of federal takings claims. And we'll have to see what the what happens at the argument. It's going to be next week, and what the what the court ultimately does. But depending on how the court decides that case, it could conceivably channel takings claims, which is a significant volume of claims in the Court of Claims, into federal court. We'll just have to see what happens. And then, if I have a moment, I'll finally just mention, last year when I was here, I thought one of the important cases that was at that time pending and could have been major Supreme Court precedent was the PHH versus CFPB case about the constitutionality of the structure of the CFPB, the Consumer Financial Protection Bureau, which, for those of you who may not be familiar, is headed by a single director who's subject to a for-cause limitation such that the president cannot remove that director except for inefficiency, neglect of duty, or malfeasance in office. And there's a question about whether that for-cause limitation is constitutional or intrudes impermissibly on the president's executive authority. To make a long story short, the PHH case was resolved in a way that actually gave PHH a victory, although it rejected this executive authority ground for PHH's challenge. And the ultimate resolution meant that PHH was in no position to take that case to the Supreme Court. So that particular litigation is over, but subsequent to that, there has been a district court in the Southern District of New York that has declared the Consumer Financial Protection Bureau's structure unconstitutional. And in the Fifth Circuit, there was a case that just earlier this year holding that a comparable agency called the Federal Housing Finance Authority is also unconstitutionally constituted on the same theory that the dissent in the PHH case had embraced, which is basically that there's a single director for this agency that is subject to a for-cause limitation, and that is impermissible because for-cause limitations, at least one might say traditionally or one might say by happenstance, have only been imposed over the last 60, 70 years on multi-member agencies. So two cases pending before the court and this litigation about for-cause removal, I think those are going to be interesting to watch over the next year.
I thought, just a quick note, I thought it was interesting in the FHFA case, the way the Fifth Circuit sort of pointed to the D.C. Circuit's reasoning in the CFPB case, but then said, and this agency is even worse than the CFPB case, tried to make the CFPB sort of the sort of easy baseline and put their case above it. So I thought interesting.
Yep.
Anyway, Kendall, what are you watching for?
Sure. So I'm actually going to talk about something that's not yet before, or maybe will never be before the Supreme Court, but is percolating in the lower courts. But first, I was also reflecting on our talk last year, and I'm going to start with the same anecdote, which if you're here, you can tune out. But administrative law anecdotes are sort of hard to come by, funny ones at least. So I, as you know, clerk for Justice Breyer, who used to teach admin law, and he, at the end of one of his semesters, got the student reviews of his teaching, and he was reading sort of this comment box, and the person said, you know, I wish that Professor Breyer's admin law class would go on forever. And he turned it, you know, he's very flattered, and then he turned the paper over, and the person said, because each hour feels like an eternity, and then I would be immortal. So I hope that you guys don't feel that way right now, but I will try to keep this short in any event. So I'm sure you all are aware that last September, the Attorney General rescinded the Deferred Action for Childhood Arrivals, or DACA, memo, and that same day, the then acting Secretary of Homeland Security also issued a memorandum that instructed the Department of Homeland Security to reject all initial DACA applications and to, in short order, stop processing DACA renewal applications. So, if you already had DACA status, you could renew, but if you had not yet applied, you could not seek DACA status for the first time. And shortly thereafter, there were a lot of different lawsuits filed across the country. There were two, one in California, one in New York, where the courts enjoined the rescission as to the people who were seeking renewals of their DACA status. And in one of those cases, in the California case, the government actually sought cert before judgment, which is very atypical and was not granted by the Supreme Court. There was a district court in Maryland who enjoined the rescission insofar as it required or as it allowed sharing of information from DACA beneficiaries with immigration officials for deportation purposes. And then there was a district court here in D.C. Who enjoined the rescission both as to renewals and as to new applications, but that judgment was stayed pending appeal, which is something that the plaintiffs in that case actually agreed to stay it as to new applicants. And then on May 1st of this year, Texas and 6 states filed a lawsuit in Texas challenging the original DACA program, arguing that that in itself was unconstitutional, and initially at least seeking a preliminary injunction of the injunctions, essentially requiring the original DACA program to be implemented. And there was a hearing on August 8th in that case on the preliminary injunction question, and the court ultimately did not grant a preliminary injunction. And maybe part of the reason that happened is because whether to grant a preliminary injunction is a multiple factor test, but one of the factors is the sort of overarching theme is you want to preserve the status quo. And since all of the cases at that time were only allowing renewals to be processed and not new applications, there was sort of arguably less concern about disrupting the status quo if a preliminary injunction wasn't granted. So why are these cases interesting, other than sort of generally as people? Why are they interesting? So of course they raise a common problem when administrations change, which is how much does a new administration have to explain its position when it wants to rescind a policy of a prior administration. And but to me, the more interesting issue is the question of nationwide injunctions, which this is not the first case to raise the permissibility of such injunctions, but then they've been happening with increasing frequency. So also in the travel ban, for example, the travel ban litigation, the sanctuary cities litigation, and it's sort of similar to some of the other issues that we've been talking about, in that they're sort of they don't always, people's positions on the permissibility of nationwide injunctions does not always line up with or there's not a clear political breakdown. I mean, there's sort of tendencies, but people on both sides of the aisle have different views about whether nationwide injunctions are permissible. So just to sort of cover the high-level views on this topic, so Justices Thomas and Gorsuch have both expressed disagreement with the use of a nationwide injunction. And just taking a step back, so nationwide injunction. So in general, a court only grants relief to the parties before it and only can establish law for its circuit. But in a nationwide injunction, effectively, a court is creating law for the nation and not just for the parties before it. And many commentators, aside from Justice Gorsuch and Thomas, have criticized this practice because, for a variety of reasons, but one is that it sort of allows arguably it allows parties to forum shop, so they can seek a friendly judge, which is exactly what's happened in this DACA litigation. You know, the states went to Texas, no surprise. Plaintiffs, California, New York, DC, Maryland. Also, if there's a nationwide injunction, issues can reach the Supreme Court without having as much time to percolate, so having the sort of disagreement among the courts, which can help the Supreme Court sort of understand all facets of a problem. And many people also think, you know, this is exactly why we have class certification requirements, and you should, if you want to seek this type of relief, you should have to be a class. On the other hand, people who are in favor of nationwide injunctions often say, well, in many circumstances, you can't really provide effective relief unless you have a nationwide injunction. So, you know, for example, if well, the travel ban is a good example, or if a woman is seeking admission to a single-sex public educational institution, does it really make sense if you only grant her relief? And, you know, class certification requirements are not always, they don't always make sense for people who might necessarily not be able to meet those requirements or are not able to file quickly. So in the travel ban case or the DACA case, for example. And then finally, sort of when a district court or when a court rules on a rule, like an agency rule, with nationwide effects, for example, like an EPA rule that has to do with the environment, it doesn't really make sense to do anything that doesn't have national repercussions as relief. So the Supreme Court has not yet taken up this issue, and it could have probably a few times, but most recently there was, in the travel ban case in June 2017, it actually allowed a nationwide injunction to stay in place, which, you know, doesn't mean a whole lot. It could just be waiting for the issue to percolate more. It could just not want to deal with it. But I think that we will, and we already have, increasingly seen nationwide injunctions, and I think eventually the court will have to address it, whether it's in the DACA litigation or a comparable suit.
Thanks. And Aaron?
Sure. So the Supreme Court last term, I think one of the underreported stories was there was a great deal of hostility to Chevron. It wasn't, no one called it outright, well, maybe they did, depending on how you read what Justice Kennedy did at the end, for it to go away. But when Justice Gorsuch in particular had the pen, he took some body shots at Chevron. And, you know, again, you had a fight between him and Justice Breyer about what is going on. There isn't a case on the docket this year where they say, should Chevron be overruled? That case, I'm sure a petition is filed somewhere raising that question. That's not on the docket. But like Aditya was saying, every Chevron case, watch and see what happens in those cases, because that's where you're seeing some action on the court. Last year, to go back to our theme, my thought was if you want to understand where the Roberts Court is on Chevron questions, the case you really need to read is City of Arlington v. FCC, which doesn't seem like the most important case. It's, you know, it's not especially high profile, but you have a fiery dissent by the chief who doesn't often write such dissents, and he was joined by Justices Kennedy and Alito. So you say, well, why does that matter? Well, since then, Justice Thomas has gone from, in the majority, with Justice Scalia in the majority upholding Chevron in that case, has now essentially said it's all unconstitutional. So he's flipped beyond everybody else. And now you've replaced Justice Scalia with Justice Gorsuch, who is also, I think, closer to where Thomas is than to the chief, which means that the chief's vision of Chevron, in theory, he might have 5 votes for. So what is his vision of Chevron? It seems to me his vision of Chevron is we want to keep it as a framing device, but we're going to have more exceptions to it. And on that theme, a case that I found, you know, it's an undercard. It's not one that I think most people are talking about. It's called Nielsen, so I like it already.
That's his last name.
The PREAP, or PREAP, I'm not sure, it's P-R-E-A-P. And this is a case about immigration law. And I thought it was interesting in its own right, but also for the move which they make, which I suspect we're going to see a lot of. So the question is about, here's the issue, whether a criminal alien becomes exempt from mandatory detention under 8 U.S.C. 1226C at this point you're like, who cares? Because it's hard to follow, and unless you're in the immigration space, it's hard to know what this means. But continue. If after the alien is released from criminal custody, the Department of Homeland Security does not take him into immigration custody immediately. So you say, okay, this is an immigration case. Well, in the brief, which is very good briefing, they have a section where they say why Chevron shouldn't apply. And they go through the ordinary arguments why Chevron shouldn't apply. The statute is clear. Then they have the second one, which is interesting, where they say, well, this is a constitutional question, or at least constitutional avoidance, so stay away. And then they say, deferring to the BIA's definition of the scope of the executive's detention authority would be at odds with the federal court's traditional exercise of de novo habeas corpus review of executive detention. And they go on to talk about why detention issues should always be de novo questions. Now, in the immigration space, assuming the court were to accept this argument, this might be quite important. But the pattern of the argument is what's interesting to me. And by the way, and then they cite Justice Kennedy, who towards the end of the term expressed some discomfort with Chevron, and then Justice Gorsuch from his 10th Circuit opinions, which are often in the immigration context where he would express discomfort with Chevron, and that's what they cite. And it seems to me that we're going to see more of those type of arguments, where they say, here in this particular situation, whatever Chevron's value elsewhere, in this particular situation, that you should make an exception for it. And I suspect we're going to see a fair number of those types of arguments. Now, whether they succeed or not, I am not sure. But that strikes me as interesting and to watch, because I think last term all the Chevron cases, or I think all the Chevron cases, had interesting things happening in them that are worth reading. Things are building to something, and I suspect they're building to something like the Chief Justice's dissent in the City of Arlington. Beyond that, real quick, I follow the D.C. Circuit, so that's where most of my attention is focused. I think fascinating. One, Adam is right. We're going to start getting the big rulemaking challenges because it takes time for that to happen. So we're going to start getting those. But what we have already been getting are the challenges to agency efforts to stay the Obama-era rules. So once President Trump came in, the very first thing that happened, or one of the first things that happened, was they used the Congressional Review Act to get rid of, I believe, 14 of the big rules. At the same time, what the administration was doing for a lot of these big rules is they were staying them and asking the court, we're going to rescind this rule, so don't make it go into effect. And the D.C. Circuit in particular has not been entirely comfortable with that. So last year we had a case which was Clean Air Council v. Pruitt. And then more recently we had Air Alliance of Houston v. EPA, which was Judges Rogers and Wilkins. Judge Kavanaugh had been on the panel. Once he was nominated, he stopped hearing these cases. And there they said, no, we're not going to let you keep delaying these things. The rulemaking process says once you finish the rule, it's a final rule, and it has to go into effect. And you keep asking us for permission to stay, or so it doesn't have to go into effect. Well, we're not going to let you do that. And then last week, they asked for a short period of time, the EPA asked for a short period of time, just so we can get through the process of, of the new rulemaking. And the court said no. Again, the same two judges. And then in the Clean Power Plan litigation, which of course was the rule itself was stayed before Justice Scalia passed away. They keep asking, 60 days more time to go through the new Clean Power Plan. What's the next step? And you see frustration some of the judges on the D.C. Circuit that this keeps happening. So the last time they asked for the 60 days, you had Judges Tatel and Millett saying, at some point, this sort of approach to regulation has to stop. You have to actually, change the rule or enforce the rule, but it can't go on forever in this. You just keep kicking it down the road. So I had one of my assistants look at all of the cases, not just in the D.C. Circuit, where this issue has come up. It's actually coming up a lot in the district courts. In the D.C. Circuit, those are the main cases, but it's come up in a couple of the other circuits. There are a lot of district court cases where they're saying, you keep asking for a stay or you keep asking for a delay, and we're not going to let you do that. I think that's interesting to watch, and we'll see. It's possible all these issues will be mooted out because now the time is coming where the agencies are issuing the new rules, which really then are undoing what came before. But to the extent that you have delay, I think it's interesting to see what the courts are doing. And my sense is that they are not happy with all these requests for additional time.
Well, before I give everybody a chance to sort of react to what's been said, I do want to keep things on the Chevron issue for a bit, because it's been talking about it so much the last few years. But what you said before, I found particularly interesting the way you put it. You said it's all building up to something, right? But it's not clear what the something is. And you kind of grouped together Gorsuch and Roberts and Thomas, but you also indicated along the way there's a big difference between the way Roberts approaches the Chevron issue and Gorsuch and Thomas, right? Gorsuch and Thomas have been talking about Chevron much more in terms of first principles of judicial duty and so on, where Roberts seems very content to sort of, he's maybe of the mend it, don't end it school, right? And so it's not clear that Roberts's natural alliance in a given case, depending on how far Gorsuch and Thomas want to take it, is with them rather than with, say, Breyer, right, or others on the other side of the aisle. There's no aisle at the court, but you know what I mean. The justices who even before the conservative justices were picking up on this, were calling for reform. I'd just be curious for everybody's sense of how this sort of reckoning might come in the Supreme Court, if at all, over Chevron, where this might all shake out. Any predictions? Aditya, please.
You know, it's impossible to say. So I'll make a prediction in another way, because we just can't predict what the court's going to do. But I've thought about the issue this way, which is that there are the wholesale rethinkers of the type, the ilk of Justice Thomas or Justice Gorsuch, and then there are the will carve out exceptions along the way thinkers of the type, conceivably, of Chief Justice Roberts. And you know, it just seems to me that for decades, the way in which Chevron has been taught at law schools is, here are the 2 steps. These are the 2 steps you need to know for the Chevron doctrine. And there will come a time, if enough exceptions are carved out of the doctrine, that will not be the way in which textbooks will present the issue. And it would be malpractice for professors to present the issue to their students that way. And I think to this day, I mean, at this point, I don't, to this day, I still present Chevron as a 2-step process, but then I point out that there are, 6 or 7 different ways to think of the exceptions. And I just wonder, you carve out another exception or two, and I think you just flip that rather than, there once was a time when we thought of this question from the perspective of the 2-step process, but we don't anymore. And whether that happens, wholesale reworking of the doctrine or incremental chipping, it's hard to know.
Right. Well, there's Chevron Step 0, and last year, the year before, Aaron, you wrote a piece on Chevron Step 1.5, and other scholars say Chevron has no steps at all. So, any other suggestions?
You don't need
how
to
many
write
steps
articles and get
Chevron
tenure,
is?
right? I don't know. Oh, I was just going to make a joke about law professors wanting to write articles, but that's, anyway. No, I think it's more, I mean, look, the court seems to really prefer, in a lot of instances, obviously, to write more incrementally. And so, I mean, Justice Gorsuch, just this last term, when he could have made broader statements about Chevron, just instead sort of, tightened up Step 1 in the sense that he did just a lot more work of statutory interpretation up front. So, I mean, conceivably, the court could just continue to handle Chevron questions that way, particularly if a party does not choose to present a cert petition in a way that puts to the court the question, should we overrule Chevron? I mean, I think unless a party framed it that way and the court granted cert on that question, you might not see a majority of justices getting rid of it. And that's certainly a viable approach. I mean, the challenge that it brings, obviously, to the lower courts, then, is they're not necessarily, like, they're given instructions on how to interpret that particular statute. Agencies know how to interpret that particular statute. But it's really hard, unless the court explicitly says you need to apply these canons of construction or take these interpretive approaches and put them into Step 1. I think it's hard for that to have an impact on how lower courts in a uniform way apply the Chevron analysis moving forward, because every case is going to have different factors, different things you can construe from the statute, different tools you can bring to bear. So just spending more time at Step 1 is not necessarily instructive moving forward, I don't think.
Kendall, any Chevron thoughts?
Not useful ones, really, or not additive ones, I think. I don't have any real predictions that go beyond. I also tend to think it will be chipped away, and I just don't know what it will look like.
Well, then, in that case, let's look back at all the issues that were raised so far. Kendall, is there anything that the other speakers said that sort of piqued your interest or or anything you'd
Wow,
like to add
that's
to?
a lot of pressure.
Yeah, not to put anything on you. I mean, the non-delegation case is sort of interesting. We have a straightforward non-delegation case in the Supreme Court, right? Cass Sunstein famously said or wrote, non-delegations had one good year and 230 bad ones, or something like that.
Right.
And will this be another good year for the non-delegation?
So I
doctrine?
actually can't talk about that case.
We could turn off. If you have something
Yeah.
really interesting to say, we could turn off the cameras. So, well, what do others folks think about the Gundy case and non-delegation?
So I was at a conference with a bunch of state solicitor generals over the summer, and the question that I asked is, who voted to grant cert in that case? Because if we could reverse engineer to figure out who voted to grant cert, then it tells us a lot what the court is interested in doing. And this one I have no idea, so I'm just kind of freelancing here. I think it's safe to say that Justice Gorsuch voted to grant. I mean, that's easy. We know that because he is the only circuit court judge in the United States to say this is unconstitutional non-delegation grounds. And then a year later, he's at the Supreme Court, and sure enough, they grant that case. So that's a safe one. I think it's safe to say that Justice Thomas is there as well. In recent years, well, even all going back to Whitman, he has expressed discomfort with intelligible principle. So you say, well, that's two, but that's not enough. So where do the other votes come from to grant cert on this? And I wasn't sure, and I just kind of threw it out to the crowd, well, what do we think? And somebody said, you know, these are pretty savvy folks. Someone said, well, I suspect that the other two votes came from Justices Ginsburg and Sotomayor, because they think that this particular context of criminal law makes it unlike ordinary and non-delegation. Well, if that's the case, assuming that they can pick up 5, which, if that's the coalition, probably they can, but I'm not sure. The doctrine will be a pretty narrow decision, and it'll be about criminal law. It'll say whatever in the ordinary context when it comes to criminal law, fair notice is especially significant or something, and that's kind of how that case ends up. But if that's not the group, if instead it was, I don't think it was, but let's assume that the Chief Justice was one of the ones who voted to grant on that. Well, then it's a whole other ball game, because then it can be, you know, a much larger decision. So listen at oral argument and see who speaks up and the questions that you get, because I think that'll tell us a lot where that case is going to end up.
You keep coming back to Gorsuch on this. In addition to his previous opinion on the lower court, he had that separate opinion this year in the DiMaia versus Sessions case, right, which wasn't delegation, but he was writing about void for vagueness.
Correct.
Which is, it's fair to say, like a sort of a sister doctrine, right? I mean, it's in the same ballpark, right? Adichie, do you have any thoughts on non-delegation?
I don't know if I have any particularly new thoughts. I'll just add that, you know, I'm not sure this is entirely accurate, because as Jen pointed out, in the Reynolds case that preceded the Gundy case, Justice Scalia had dissented and said, I think this interpretation that we're now giving to the statute poses non-delegation problems. But what I wanted to say is, it's conceivable this is one of those areas where the switch from Justice Scalia to Justice Gorsuch makes some sort of difference. And for those of you who are familiar with Justice Scalia's just general approach to legal questions, he abhorred the notion that, you know, we're going to try and figure out how much delegation is too much, how much is too much. It's going to be all a matter of, you know, gut instinct, as opposed to here's some hard and fast rules. And we will see. We'll see whether, you know, the newer justices have that same inclination to, or the same approach to law generally. We'll see. We'll see how it turns out.
Yeah, ironically, that was, you know, people have been reading a lot of Judge Kavanaugh's writings the last few months. And in his big article in the Harvard Law Review on statutory interpretation, that was his critique of Chevron, right? It was almost like Scalia's critique of non-delegation. It requires judges to make this ambiguous, unambiguous line drawing that's not a line at all. It's just all blurry. And it was ironic to see that come back around again. Well, okay, let's close the book on Chevron then and think about the nationwide injunctions issue, because obviously this is not a new issue. It came up a lot during the last presidential administration when you had, you know, red state attorney generals suing the Obama administration, and now blue state attorney generals largely suing the Trump administration. What does everybody else think about the prospect for judicial reform of nationwide injunctions? Is it a good idea? Is there a legal basis either way?
There's also, sorry, one thing to say first is, you know, I think it's unlikely to happen, but I know there has also, the congressional solutions have also been considered. I personally don't think that's likely, but it's possible.
Have you heard any details yet? I'm just curious.
Not really, but yeah.
I think it's been introduced by Representative Goodlatte, but I'm not sure if they've had a hearing or markup or anything. I think it was pretty recently introduced,
recent,
right?
yeah,
Is there a markup on it?
They did?
Yeah, they did.
Well, what do people think about the nationwide injunctions issue? Aaron, you look ponderous.
I am ponderous. I don't know if I have that much to add. I will say this. I'm gonna tie it to Chevron and watch how I do this. So one of the issues that comes up in the DACA-DAPA stuff, as well as some of these others, including Gundy in the D.C. Circuit, by the way, was does the agency or the person exercising discretion have to know that they're exercising discretion whether to do it? So if they say that this is compelled by the statute, then, and that's not true, in that the fact it's ambiguous or they have some discretion, then courts are saying that's unlawful. So you're hearing some of this with the DACA-DAPA stuff, is the new administration came in and said, this is entirely unlawful what the Obama administration did. We have no discretion to do this. And then the court says, well, wait a minute, you do have discretion. Thus, because you can exercise discretion and you say that you couldn't, that's why we're going to give you a reason to enjoin what you're doing. That was the argument the D.C. Circuit did when they had approached the Gundy issue, was the Attorney General said, I have no discretion. They said, no, sure you did. Thus, we are going to strike it down. If that's the basis, and that's not the basis for all these arguments, it seems to me that a lot of the nationwide injunction stuff can just be fixed because they just have to accept, even assuming arguendo that we have discretion, we don't think is lawful, and a lot of these arguments will go away. So now I'm going to go back to this why Chevron step 1.5 matters. Our theory is, why don't they just do that? Why don't they just say things like, assuming that we have discretion, we choose to exercise it in this way? And they often don't do that. And I suspect part of the reason, just generally, not in any specific instance, is you don't necessarily want to be on the hook for saying that that's how we. It's much easier to point at Congress or somebody else and say they don't let us act the way that we want to, than to say, no, we're doing this as our own matter of choice. So that doesn't go directly to the nationwide injunction stuff, but it seems to me that a lot of these issues, they're only an issue because we don't have an affirmative statement that's saying this is how we would use our discretion.
Anybody else on nationwide injunctions? Did you?
You know, I just don't have a particular view on this, but I think what Kendall said is the right way to look at this. This is an issue that can cut in all kinds of different directions ideologically, and the rules ought not to change. They ought not change just because somebody's ox is being gored. So this is really an opportunity for the court to get it right, and to get it right, from my perspective, is whatever statutes authorize, whatever equitable principles authorize, whatever the Constitution authorizes. And you know, now that I've done the heavy lifting, the court ought to apply those principles and make it work.
Well, and I think that's one reason why it would be nice if Congress acted, right, to get sort of consensus from both chambers, you know, an approach moving forward, and not just leave it up to, you know, the court to be telling other courts that disagree, you know, that they're doing it wrong, and then possibly, you know, change the approach later on, or leave it up to some, you know, multi-factor analysis or something.
I mean, the problem seems to be, and Kendall, you referred to it earlier, that this risk of forum shopping, right? That people will seek a nationwide injunction and pick a court that they think is likely to give it to them. Well, if that's the case, you know, maybe one sort of creative or eccentric way Congress could approach this would be, you know, they already have the lottery system for multi-district litigation, right? If lots of people are filing suits, then they go into a lottery. Well, what if there was a nationwide injunction lottery, right? That if you filed a complaint in federal court and you sought among your relief a nationwide injunction, well, then by rule it would automatically go into a lottery that would then, you know, spin the wheel and send it out to, you know, the district of, you know, the Eastern District of Iowa or something, rather than, you know, knowing that you're picking either, you know, a Texas court if you're a red state plaintiff, or a California or Hawaii court if you're a blue state plaintiff.
So I think that is creative, and I think it does
eccentric.
solve. Yeah, well, tomato, tomato, and I think it does solve the foreign shopping issue. But I also I think some of the problems people have with nationwide injunctions are more sort of historical and sort of about the court's power. And I don't think, obviously, that doesn't get rid of those problems. And I think were the Supreme Court to take up this issue, I mean, it's sort of funny in a way that it would be, they would sort of be like, this is my toy. Nationwide relief is my toy, and you can't play with it. But I think many people on that court would sort of have these sort of more purist problems with nationwide injunctions.
So I got to say, I don't think it's going to solve the problem, in part because plaintiffs are, there are more plaintiffs than the one. Yeah. So unless you're going to consolidate the cases with, maybe that would be part of the statutory scheme. Each subsequent plaintiff to file, you would consolidate with the first plaintiff. Yeah, sure. But assuming that it's kind of like if you're able to double or nothing, a poker game ad infinitum, at some point you're going to hit the right target and you're going to win at some point. So,
but then there's also, but then if you already have nationwide injunctions going in one way, like the DACA thing is unusual because you can get two conflicting nationwide injunctions. Because the one litigation is challenging the 2012 program and one is challenging the current program. So it's not that common that you would have two injunctions going in different directions, but then that's sort of an interesting question too.
So I'll just say in response to both of your thoughts, if in fact the concern is forum shopping, we already have statutes that channel certain types of issues to certain types of courts, and we can do the same thing. There's no prohibition on Congress channeling certain sorts of administrative law challenges to, or only granting the D.C. Circuit, for example, or the DDC, the authority to grant non-party relief. Although I suppose that would have to be written in very careful ways in order, unless Congress in fact wanted to change the rules for class actions or other things like that. But conceivably, you could channel certain kinds of cases to certain kinds of courts in order not to lead to some sort of disuniformity.
Yeah. Well, we have a lot of practitioners in the audience who are very expert in a lot of these areas we've already touched on. Do we have microphones in the room? We have a microphone in the room, so if you want to ask a question, raise your hand and the microphone will find you.
Nationwide injunctions. One is, at least part of the concern, I think, is for plaintiffs, you file once, twice, 3, 4, 5 times, lose every time. The government gets it doesn't really get any benefit of those rulings. If you go to a District Court number 8, you win, they issue a nationwide injunction. They've effectively overruled, not literally reversed, but effectively made meaningless all the government's victories up to that point, which seems a bit unfair, at least from a former government attorney or current government attorney's perspective. The other is, I remember years ago there was a Supreme Court case that essentially directed courts of appeal not to apply, what was it called, non-mutual collateral estoppel against the government in order to allow the government the opportunity to develop circuit splits. One effect of a nationwide injunction is to prohibit the government, on pain of contempt of court, from attempting to develop a split by bringing or defending the same regulation or enforcing the same regulation in a different judicial circuit. Those are two issues that seem of some importance to me for the nationwide injunction context. I don't know if anyone has any thoughts about either of those.
Anybody have any, please?
Yeah, I wonder if the case you were thinking about is a Taylor versus Sturgill. Is that the case in which the FOIA lawsuit is being brought by one party who loses against the government, and then the second party brings a lawsuit? It's not the one. Well, so that's a case from the Supreme Court. It's just what springs to mind when you raise the concern. And the point is that, we have this principle as a fundamental aspect of American law, which is that non-parties are not precluded by previous adjudications. And one of the fallouts of the principle then is that in cases as small as FOIA litigation, we can have repetitive lawsuits brought all across the country in different districts. And that was the Taylor versus Sturgill case where one person could sue and ask for a certain batch of documents, lose, and then somebody else would go to another district, sue, and lose. I take it that the concern is heightened in the nationwide injunction context because of the nature of the relief. So I think you're quite right that it's a combination of the fact that we have as a principle of American law non-party preclusion, which allows people to relitigate issues that other people have lost, and also this this type of non-party relief that is being given in the nationwide injunction context.
Any other questions? I mean, I have one that I'll throw on the pile then. One of the first things that President Trump did on taking office was issue Executive Order 13771, right? An across-the-board regulatory reform executive order. We've been living in the world of OIRA oversight, now under Executive Order 12866, but dating all the way back to Reagan, with cost-benefit analysis and so on, and interbranch or interagency deliberation for executive branch major rules. And President Trump and his White House really took a totally different approach to this, right? Or a significantly different approach. The old order is still on the books, but now adding these requirements of a regulatory budget of a sort for agencies, and also, I guess you call it the 2-for-1 deal, right? There's a requirement that an agency pull down 2 regulations for each new one it promulgates. I don't think we've seen any major litigation over those yet. And I'm curious for your thoughts over whether at any point that issue will get wrapped up in any of these rulemaking challenges, or if you have any views on just the substantive legal issue about to what extent the president can layer these procedures and these substantive requirements on top of agencies.
I guess 2 thoughts on this, and one may betray my own ignorance about it. I wonder if you know more about just how this is operationalized, Adam. And that is, so there's a 2-for-1. Two regulations have to be revoked in order for a regulation to move forward. How's that operationalized? Like, how do we know that, the department, do they actually write into the regulation, here we are now promulgating a regulation and we are now revoking these 2 regulations as a result? Do we know that? Because maybe Jen knows.
Well, I mean, maybe doesn't the agency have to have reviewed like its overall plan of how it's going to move forward? So I would think they would sort of put the regulations they're going to eliminate for the new one they propose down in that proposal.
So it seems to me that part of what would prompt a challenge, if there were to be a challenge, is knowledge. Somebody would have to know that, these 2 regulations were revoked because this one was promulgated. And at that point, the people who care about those 2 revoked regulations would say, hold on a second, this is totally arbitrary. It's arbitrary that you're revoking these 2 regulations to promulgate this one. You have no other reason to revoke these 2 regulations, which greatly benefited me. I think that's the type of challenge you might see. Or alternatively, if in fact, there's one regulation that perhaps by statute has to be promulgated, and the executive branch were to say, we're not going to promulgate it until you figure out which 2 are going to be revoked, then conceivably you could see a challenge saying that this is arbitrary, they're not, or violates the statute, they're not promulgating the regulation that they ought to because they're waiting for 2 regulations, which is completely unconnected from the legality of the regulation that they ought to be promulgating. So I mean, it seems to me that it'll take a setting of that nature in order for there to be a challenge. If in fact there are a whole bunch of regulations sitting around that are low-hanging fruit that nobody cares about that can be revoked, then nobody would ever challenge this. I don't see why anyone would ever be harmed by it.
Yeah, and on that, I mean, if to go back to your two situations, if that's what they were doing, they probably would lose in court too. I assume that the way that they're operationalizing it is they are going through their regulations to find those that could be independently justified as reasons to get rid of. Or you'd say, all right, in order for us to promulgate a new rule, we have to find 2 old rules that using neutral standards no longer are cost justified, in which case they would rescind those 2 rules. But you would challenge that in court, but you would lose because it's no longer cost justified. You have to go through that same notice and comment process to rescind a rule as to create a rule. So it would be, I think, unusual for, I mean, if an agency said, we think this is a perfectly good rule, but we need to get rid of one, so I guess this one's got to go, that would be a very poor lawyering. And I don't think that's what we're going to get. I suspect it just means we have to look harder to find rules to get rid of. But the bigger part for me, I don't think is the 2-for-1. It is the net. There's no net regulatory burdens or no net regulatory costs. That seems to me bigger. The number 2-for-1 is important or whatever, but the actual budget I think is much more significant.
Well, and why is that?
Well, it's much more significant because you can just find 2 very small rules and then a very large rule that you want to promulgate a large rule and you find 2 small rules to get rid of. well, that's 2-for-1 isn't really doing anything for you there. If the goal is we want to reduce the size of the government, of the regulatory burden, it's the fact that we're not letting it get larger is the more significant. Now, I don't know how it's also much harder to police because you have to put numbers on things, and sometimes it's really hard to do that. So I don't know how I'd be curious, like Aditya, how they're operationalizing it, but at least conceptually that strikes me as a much more interesting move.
Well, that's what I sort of meant was for the reg budget aspect of this. I wonder if that raises greater legal questions than the 2-for-1 issue. Not just because the 2-for-1 issue is just sort of amorphous. And I saw, I mean, the Center for the Study of the Administrative State's founder, Naomi Rao, is now at the White House, overseeing what the agencies are doing. And early in her time in the White House, in December of last year, they issued the report saying, really, we're cutting something like 33 rules so far for every one we've promulgated. So to the extent they're keeping a budget of rules they're cutting, they're still doing well. But this idea of a regulatory budget capping the costs for an agency, that itself might be a thornier legal issue.
Yeah, I think that's right. And I think, again, Aditya, your 2 examples he gave are very helpful to conceptualize it. If Congress says enact a rule, and they say we're not going to enact this rule because we can't find money to cut somewhere else, well then, again, I think you're going to have a hard time justifying that refusal to act. Because if Congress says we want this rule, even if it increases the budget, look, Congress still calls the shots, and I think that it would be much harder for the agencies to win in that sort of thing. But let's assume that's not the issue. I don't know why, per se, it would be unlawful for them to say we're going to find rules to offset, so long as they can find them lawfully, independently, to offset what we're trying to do.
And you had asked just generally if the president would have authority to be able to oversee that, and certainly I would think, especially with what Aaron is saying, that he would be able to oversee how the agencies are carrying out the regulatory process in that way.
Well, I was just going to say, I think this links to Jen's point. It is interesting to me that, at the time these Reagan orders that established OIRA were issued, there was a huge debate about whether whether OIRA is constitutional, whether the president has the authority to direct other entities who have been vested by statute with a certain kind of discretion to, in a way, exercise their discretion in a particular way. And I suppose it does raise, and conceivably there could be challenges along these lines. It does raise conceivably just the issue of, so either because Congress has implicitly now delegated this supervisory authority to OIRA to ensure that regulations go through a particular kind of review, or because if the president has the constitutional authority to direct agencies in that way. OIRA, as it was previously constituted before the Trump orders, was constitutional, statutorily authorized. But then can we say that adding these additional authorities that allow OIRA to do additional things is also, implicitly statutorily authorized by Congress, or is it also part of the president's directive authority to agencies? Conceivably, there would be challenges along those lines. It seems as though nobody's really been thinking of that type of challenge to the orders thus far. Yeah,
that sort of absence of both litigation and scholarly interest has really struck me. I mean, about a year ago, I did a short piece for a law review symposium about the president using executive orders to give substantive direction to agencies. And as I was writing it, I was going back over that whole series of law review articles from the 80s. Peter Wallison in our audience knows this history well, right? All of the law professors debating over whether those original OIRA executive orders were constitutional at all. And the issue was never really resolved in court, and it just kind of faded away. And maybe that's why there hasn't been scholarly interest in these new orders, because it's now sort of established. But it's a much different sort of, a much different...
Maybe you should write that article.
I'm too busy running events. Any other questions in the audience? Please, wait for the microphone to find you.
Data used in notice and comment rulemaking. To what extent can an agency include new data or new justifications in a final rule after public comment has closed? So, for example, if the public says, you didn't consider these two studies, and when the government looks at those studies, they find another one, can they include that third study and use that as justification after comments have closed, or does it need to reopen?
So it's funny you ask. Aditya and I used to be law firm associates together back before we went off to go be law professors. And that was an article that we talked about writing. The doctrine in the D.C. Circuit, at least in the Supreme Court, has somewhat adopted is called the logical outgrowth doctrine, which is if the final rule is a logical outgrowth from the proposed rule, then it's generally going to be lawful, even if it's not exactly the same as the proposed rule. And our article, I think it was going to be titled The Logic of the Logical Outgrowth or something. We never wrote this thing because we're like, no one would possibly read it. But maybe we're wrong on that one.
I know. Here's our audience. We have at least one reader.
But I remember we collected all of the logical outgrowth cases in the D.C. Circuit, and we read them back and forth. And the answer is that there's a body of cases, I don't know, maybe 15 or so cases that address this in the D.C. Circuit. And sometimes they say it's close enough, and sometimes they say that it's not close enough. And beyond that, you'd have to kind of, compare your case or your facts to the cases that they've got. But the doctrine is the logical outgrowth doctrine.
Anybody else? Well,
I wasn't going to say anything about this issue, but I feel compelled, since nobody else has brought it up or asked a question, to raise one petition before the court. Well, not completely before the court because the government hasn't yet filed its response. But we talked so much about Chevron, which obviously is the doctrine that courts have to defer to agencies' interpretation of statutes, and the ever-present related our doctrine is in yet another petition before the court this time. Of course, the court keeps repeatedly denying petitions to challenge the constitutionality of our, but again, parties have filed a petition challenging our and Seminole Rock deference to an agency's interpretation of ambiguous regulations. And interestingly, there are 5 amicus briefs in support of this petition, including one filed by 19 states led by Utah, which is a similar amount of amicus briefs in favor of the petition as in last year's petition in the Garco construction case. The court, in denying, there was some suggestion when the court denied granting cert in Garco that maybe there were some procedural complexities. Everybody then, scholars sort of laughed that the court always finds procedural reasons not to take up the our challenge. This probably is a cleaner challenge. It deals with the VA department's interpretation of what are relevant service records in determining veterans' benefits. But we'll see. The one thing that caught my interest is that the government brief in opposition, which was originally due on August 1st, and then they requested an extension until August 31st, and now have requested an extension until October 1st. And I guess it's not highly, highly unusual for the government to request extensions, but I will just point out, just to be controversial, and just on a controversial note, that one case last time around where the government kept asking for extensions was in the Lucia litigation, where the government at the end of the day changed its litigating position and stopped defending the constitutionality of the appointments clause. So I'm just raising, I'm sure there are many other justifications. I'm just kind of being funny, but I'm just going to be a little bit provocative here at the end and say, look out for Keysore versus O'Rourke when the government finally files its opposition to why cert should not be granted, what it says and whether it seems like a reasonable case for 4 justices to grant cert.
Well, a year from now, when the Supreme Court has declared, has overturned our deference and Seminole Rock, and there's law review symposia and all sorts of discussions about what comes next, we'll be back here next year to talk all about it. So thank you, everybody, for joining us today, and thank you very much to our speakers.